I'm going to call this hearing of the Governor's Council to order. I'm going to begin by reading a letter submitted to the council by the governor, and then we will get moving. Dear councilors, I am pleased to nominate Nibal Raheb to the position of Associate Justice of the Juvenile Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I am enclosing the nominee's resume for your convenience. And with that, Attorney, welcome. Congrats on your nomination. We're going to hear from your witnesses. If you want to introduce the folks you brought with you today, you can do that.
Sure. I have my husband, Eli, is here. My sister, Nellie, is here, and my daughter, Joelle. And I have my witnesses, Vincent Ricciardi and Stephen Bolivar.
Okay. And I don't know if there's a preference to who joins us first. Justice Bolivar.
Good morning, everyone.
Thank you for joining us.
Thank you. Thank you. It's been 6 long years since I sat in that chair, and I remember checking to make sure it wasn't plugged in. But the 6 years have gone by in a minute. Although at that time I asked the council to confirm my nomination. I can now say thank you to the council because it's been a spectacular.
We promise on giving a motion to reconsider.
Thank you for that, but it's been a wonderful 6 years, and there's nothing more than I would love to do than continue to do the work and that brings me to my friend. I'm going to refer to her as Nibal. She's my friend. Our paths crossed, believe it or not, 31 years ago. I rented space as a young lawyer from this guy back here and another icon, Harry Damiak. And Nibal was hired then as a secretary and became a legal assistant, paralegal in the office, and we got to know one another. I had the honor of attending her wedding and watching her grow a beautiful family with 3 children. It's been a really a wild ride with my friend. After she passed the bar, I convinced her to consider the juvenile court as a source of practice. She thought about it, took the courses, took the prerequisites, did everything she needed to do, and began practicing in the juvenile court. And as I was an attorney, she was an attorney, we would occasionally have cases together, care and protection cases, co-defendant cases, and it was always a pleasure working with Nibal. Always prepared, ready to go, never shying away from difficult cases. I also had the opportunity to supervise her after being appointed through the CPCS supervisory capacity. Caused me to meet with her, review files, look at strategies, consider listening to complaints made against lawyers. And I can't tell you the stack, of course, not. Nibal has always done a wonderful job. I will fast forward it as a sitting judge in the last probably 18 months or so. I've had the pleasure of having Nibal appear in front of me for 2 very, very contested care and protection cases. And the care and protection cases are our most vulnerable population of children. And she was tasked with representing parents in a very difficult spot. The first one was a woman who had moved here from Russia with significant mental health, untreated issues, schizophrenia, I believe. The trial went over 7 or 8 days. Many witnesses testified, exhibits, many disruptions during the court process. And to her credit, every time there was a disruption, she would ask for a pause. She would ask mom to step out. They'd have a few words, would come back in, and would get back at it. Always motions in limine, everything filed proper, according. The other case, a young father who managed to sell firearms to an undercover police officer, landed him in jail. So we had a young father that she was representing and did just an outstanding job. So I believe she does possess all of the qualities. The most important quality, I would say, that represents Nibal is her temperament. And in the 31 years that I've had the pleasure to know her, in court, out of court, I've never seen her become upset. I've never seen her yell. I've never seen her call anyone out. She remains calm, deals with the situation, and moves on. So for those reasons and others, I'd ask the council to confirm her nomination. Thank you.
Thank you, Justice. We'll see if any counselors have questions for you. Counselor Dahl?
Thank you, Judge. We appreciate your testimony.
My pleasure. Thank you. Good to see everybody.
Thank you, Justice. Attorney Ricciardi,
Thank you.
good morning.
Morning all. It is a pleasure to be here. Last time I was here was about 1.5 years ago. And begin with the gravy sauce controversy. I've known Nibal Raheb 31 years. Right out of Clark University, she entered our office at 47 Harvard Street. And we have had a phenomenal relationship since that day. She's worked with us, she worked for us, she worked with us, and she blossomed into one of the best juvenile district court lawyers in Worcester County. Her reputation is outstanding. I prepared a written presentation today, but over the years, I've watched this person develop into a zealous advocate for her clients. She is diligent. She's prepared always, as Justice Bolivar has said. When she has a question, she consults with us, with lawyers in the office, with people in the courthouse. She's always looking for the right avenue to pursue. And she's done it. And she's done it on a daily basis for years. We began practicing in the juvenile and district court, I believe it was 1999, correct? And in her reputation for being a zealous advocate, standing as a supervisor of the Worcester Bar Advocates for Worcester County, she's attained a reputation of being a responsible person for lawyers. They look up to her. They ask her questions about many, many different things on their cases. And she always has the answers. And I've known her as well as my daughter, Judge Curry. They were both supervisors of the Worcester County Bar Advocates as well as Justice Bolivar. So out of our little office at 47 Harvard Street, we now have what I consider to be 3 juvenile court judges, which we are very, very proud of. I kind of take the old fatherly approach here. All right, the kids have done well. The kids have done extremely well. I just can't believe this is all happening to you. I'm so proud.
Thank you.
All right, and with that, I just ask you all to vote positively as soon as you can, so that we can be sworn in her robes fitted, and we can proceed. Thank you.
Attorney, there's a lot of folks who call me applying for judgeships, and I think they all would be well advised to find a way to work for you.
I'm tired now, so it's
Well, persistence perhaps will pay off. Do any counselors have questions or comments? Judge Curry's doing an outstanding job. It's good to see you. It's good to see you again.
God's not doing so bad either.
what was it?
He's not.
Yeah. Well, keep that contact.
I'll just confirm that there's no witnesses here seeking to offer testimony in opposition, there being none. It is your time to offer a statement, and then we will hear questions from the council.
Good morning. It's with deep humility and gratitude that I appear before you today as Governor Healy's nominee for Associate Justice of the Juvenile Court. I thank Governor Healy and Lieutenant Governor Driscoll for this nomination and for entrusting me with the immense responsibility of shaping the lives and futures of juveniles and families across the Commonwealth. I would like to thank Chief Legal Counsel Jesse Boodoo, former Chief Legal Counsel Paige Scott Reed, and Deputy Legal Counsel Dara Kesselheim, who has been a pillar of support throughout this process. Thank you for Sonia Altamirano and her team for guiding me through these steps. To each member of the Governor's Council, thank you for taking the time to meet with me, to speak with me, and to thoughtfully considering my nomination. I especially want to thank my family, my husband Eli, who sacrificed his career for our family, my daughter Joelle, who is entering her freshman year at Boston College, my sons who could not be here today, Alex, who just graduated Boston College and is working as a medical assistant, and Michael, who is a rising senior at Bentley University and is captain of the football team. They have stood by me every step of the way. I also thank my sister Nellie, my friend Judge Steve Bolivar, and my friend and mentor Vincent Ricciardi, who have all played a major role in my journey. My journey began halfway across the world. I immigrated to the United States from Syria when I was 10 years old, along with my family. My parents were humble, hardworking people. My father, a tailor, my mother, a homemaker. They brought us here seeking safety, freedom, and a better life for their children. Like many immigrant families, we faced many challenges. Not speaking the language, adapting to an unfamiliar culture, and starting over with little. But no challenge was greater than losing my father unexpectedly soon after we arrived. His sudden death was a defining moment, one that forced me to grow up quickly and taught me how grief and resilience can coexist. Through heartbreak and hardship, we persevered as a family. We settled in Worcester, where I attended the public schools there, worked there, and lived there all my life. From a young age, I knew I wanted to become a lawyer because I wanted to protect the rights and dignity of others, especially those whose voices are often unheard. My personal history inspired that path, and it continues to deepen my respect for the law and the judicial process. I began working as a teenager and have worked continuously ever since. While commuting to law school every day, I worked 2 jobs as a legal secretary. It was not easy, but it was driven by purpose. Through it all, the one constant in my life was my mother, who encouraged me every step of the way to aim higher and never give up. Though she is no longer with us, I know that she is with me in spirit today, beaming with pride. Upon becoming an attorney, I opened my own practice and began serving as a bar advocate, representing indigent individuals charged with criminal offenses in the district court. It was during that time that my friend Judge Bolivar introduced me to the juvenile court, and it was there that I found my calling. Although I continue to represent clients in the district court, my deepest professional connection has been with the children and families who appear in the juvenile court. Over the course of my 26-year career, I have represented young people in delinquency and youthful offender cases where they have been accused of criminal behavior. I have represented children or parents in child requiring assistance cases where parents seek help because a child is truant or struggling at home, and also represented them in care and protection matters where concerns of abuse or neglect are brought before the court. I have witnessed firsthand the struggles these families face, and I have worked every day to ensure that their rights are protected, their voices are heard, and their futures are not defined by a single moment. The most rewarding aspect of my practice has been helping children and families through this very difficult time by guiding them through the legal process with a strong commitment to being a dedicated and effective advocate. For the past 4 years, I have served as a supervising attorney for the Juvenile Bar Advocate Panel in Worcester County. In that capacity, I have mentored and supported attorneys who work with vulnerable youths and families. It has been one of the most meaningful experiences of my career. My legal career has been grounded in advocating for children, families, and individuals in crisis. I have been guided by the belief that justice must be fair, but it also must be humane. The juvenile court balances accountability with compassion. It has the power to not only enforce the rule of law, but more profoundly to educate, to rehabilitate, and to guide young people in order to make a positive impact on both their lives and their families. If confirmed, I will bring to the bench not only legal experience and integrity, but also a lived understanding of adversity, resilience, and hope. I will approach every case with impartiality, diligence, and a deep respect for the dignity of those who appear before the court, especially the youth whose futures are shaped by our decisions. Thank you again for the opportunity to be here today. I welcome your questions and your thoughts.
I'm gonna start with Counselor Kennedy, because he has a meeting to attend, so.
I have to go to a meeting at 11:30, so I have to step out for a few minutes, so I asked, my fellow councils for courtesy going first. I don't have a lot of questions for you at all, because we spoke on the phone for some time and, you answered them all. I have to vote for you because I'm tired of getting phone calls from the, I Worcester Bar again. Is there anybody in Worcester that doesn't like you? I can't find anybody. I've been trying hard, but I can't. You have terrific credentials on the CNP side of things and the chins and stuff like that, but how are you gonna address the issue of the lack of experience on the delinquency side? I believe there was issues there, right? You have a lot of delinquency experience?
I have 26 years worth of delinquencies.
Okay.
Yes,
Understood.
yes.
Okay, so you've done a lot of delinquency.
We've done a lot of delinquencies
What
and
would you say you've done?
delinquencies, 30, 35. A lot of bench trials. I've done about 30, 35 criminal cases, district court also, of jury trials, but much more in the hundreds of bench trials, delinquency in criminal cases. And
That's terrific, because we do get people in here that don't have that much experience, and it's really nice to see that. I don't have any other questions for you. I'm gonna be voting for you.
Thank you, Counselor.
Thank you for taking me out of order.
Counselor Dolan.
Hi, it's really good to see you. I appreciated our discussion to meet with me. I know that Counselor Paul DiPaolo is a big supporter of yours. I got a wonderful letter from Judge Mary Beth Keating, the first justice in the Worcester County Juvenile Court, talking about your experience and all of your skills, and I was very impressed with that. And of course, as I told you, Judge Jen Curry called me herself to tell me how good you are, and as I told you, if she says someone is good, then they are. So I don't have a lot of questions, but I do want to talk about a couple of things, and thank you for having something unusual in common with me. We both got our start as legal secretaries, and I really appreciate that background and what that says about you. So, and uphold the honor of the profession of being a legal secretary, because it is a very honorable one. I appreciate the fact that you were an English language learner. I think that will give you insights to people who will appear before you who are also English language learners. One of the things that I asked you about, and you said you agreed with me, because I have also worked in juvenile court. Once you understand all the things that children are dealing with, almost all the time, it is amazing that they are doing as well as they are. And you agreed with me, which I really appreciate. And you wrote on your application that the juvenile court is not a punitive court. So can you just speak to, incorporating that understanding that children are doing much better than we have any reason to expect them to, and the fact that the juvenile court is not a punitive court with your view of sentencing of children?
Absolutely. What I meant when saying that the juvenile court is not a punitive court is because it serves to try to help and assist children. We all know that children develop differently, and they are kids, and their brain has not developed fully when they may enter the juvenile court system. And therefore, you want to give them some opportunities to make better decisions, some opportunities to choose a different path. And it is very important, I think, for judges to have discretion in that aspect, to allow children to be better people, and not to immediately, commit them to DYS for criminal offenses, to give them those opportunities of probation, to try and provide them with some services that they can comply with, to educate them better so that they become much better productive members of society, rather than taking the path of criminal behaviors and leading them into the adult justice system. So I think the juvenile court serves a great, it's needed that they serve that part of it, and not really punishing kids for every criminal offense.
I think that's essential because in my experience in representing children is that they have a tendency to fault themselves because they don't understand that they're there because they're not getting the supports they need. So to have a judge who understands that, sure that they understand that well, I think was critical. So the only other thing I want to say is that, as I told you, I thought you wrote an outstanding memorandum of law. I thought it had remarkable clarity, and I liked it so much that I kept it, and I did. So thank you. No further questions.
Thank you, Counselor. Counselor Civil, do you have any questions for the nominee?
Good morning, and congratulations on your nomination. I'm pretty sure all my colleagues have already asked you the questions that I would probably want to ask. But my only question for you is, what strength do you think you can bring to the juvenile court?
I think the biggest strength that I would bring to the juvenile court is my own background, my adversity. And I think that adversity would help me in recognizing what the people that are coming into the juvenile court, what they are faced with, whether they're coming in from different backgrounds, if they're coming in from different countries, if they're coming in with other issues that they have. I think that would be the biggest asset that I would bring with it.
And also, I want to state that it was great to having a great conversation with you over the phone. And one of the things that stuck by me is that your cultural background, how you'll be able to see the signs when you're dealing with people from other cultures and they come in. The laws that they used to deal with in their own country may not be the same, will not be the same in Massachusetts. So when you have a parent that is disciplining their child and, you know, for some reason they come into court, how do you help manage the differences of culture and making sure that, one, the parents are getting the resources and access they need in order how to raise a child in America or in Massachusetts, versus, you know, some of the disciplinary actions that they would take in the country that is not normal here.
Right, certainly to educate the parents about the differences of the cultures. We do live in a culture that treats discipline much differently than some of in the culture. What I mean is in America, what some of the other countries would treat discipline. And we do see a lot of families coming into the juvenile court on care and protection case matters because of their lack of understanding of what is acceptable here in America versus what is acceptable in their country. And it's imperative that they be educated on that. And it's also imperative to make sure that they have the resources, whether it would be through service providers, that they are able to understand that and work towards that.
Thank you, Counselor. Counselor Iannelli.
Thank you very much. Right off the bat, he's the biggest supporter. Big support of the problems CJA was submitted, he called me. I want you to know that. Now, you graduated from law school 1998, 1999. So right off the bat, you went to private practice?
Yes,
It's hard to do, isn't it?
it is very difficult.
I can't find that you just pass the by, you open up an office, and I don't care who you are, how you clients are not easy to come by.
They're not. It was very difficult. Like I said in my statement, I had a great mentor in Attorney Vincent Ricciardi. And when I graduated law school and was ready to tackle employment, he stepped up to it and said, you know, I have an office here. if you want to utilize this office for your own practice, I would be more than happy to have you join me in that. And I started and I decided to become a bar advocate. I took the zealous advocacy training in order to become certified in that, and that allowed me to participate in the bar advocate program in Worcester. Started taking cases in the district court, and then eventually also became certified in the juvenile court, and started taking matters in the juvenile delinquencies as well.
So it says here, who did you work with firms? It says, you know, Vincent Ricciardi for like, number of years, shared office space, so you had no, you can argue it in shared space.
Shared office space,
You had
shared,
his cases, you had yours.
yes,
And the same thing with Attorney Jennifer Curry,
yes.
she. Oh, so you never worked, since you became a lawyer, you never worked for anything other than yourself. That's high. I'm just thinking about, I mean. It's not that you can support staff, it means not to get a case. The only question I was confused at was this one. Number 6, employment. Since college, it says. Basically, what did you do since college? It makes it seem here that you didn't work since college.
No,
I had to read the question, it says, list all jobs had since college.
I think I took it since law school, I believe is the way that I may have read, I may have read since college.
Since college.
Oh, since college, well, that's a discrepancy.
Practice. Don't work.
No, that's a discrepancy part, so in college, I did work for Atty. I also worked for, it's on my resume, I also worked for Merrick O'Connell, which is one of the larger firms in Worcester, after graduating college.
Okay.
For a couple of years. So I went to law school.
Oh, that's good. Thank you, clarify.
Oh, yes.
Okay. Here's a question. There's so many good people and very, very talented lawyers who do bar advocate work. I did, it wasn't called bar advocate, when I first started out, I did that type of work, it's so much different now. It was, in my days, you can believe it, the ones who hustled the most would get the most clients. Because you could go from, there was no such thing as duty day, every court was duty day, you could go to here, there, every court. So the situation now, I'm not as familiar as a lot of people, but a lot of these lawyers are not working because they feel that they're underpaid, is that correct?
Yes.
How does that affect if you're confirmed the juvenile court? Because if it continues.
Well, certainly, if it continues, it will definitely affect the flow of the court. Certainly, we can't be hearing cases as well as we're able to. If there aren't any attorneys that are going to be representing the juveniles in court. So it would definitely become an issue for the court to handle unrepresented clients. Hopefully it does not last too long.
Now, is anyone ever in custody in the juvenile court?
There are instances where juveniles are placed in custody, in detention pending, pretrial detention
So what
in the
happens-
case.
I understand it, just for reading the newspaper,
Mhm.
so there will be the defendant is indigent and he qualifies for a bar advocate. If he's held in custody, then after a certain amount of days, I don't know, 7, 10, whatever it is, you have to release him. That's your understanding?
That is the understanding. That is the LaValle protocol that the SJC had put in place at this point for defendants who are unrepresented and are held in custody after 7 days that they would be released from custody. What I would say though, currently in the juvenile court, we have not seen as many issues with bar advocates not taking duty days. It has been more prevalent in the district court rather than in the juvenile court.
And until recently, you were a bar advocate for
Yes.
what's your position on that? Because it's controversial. There are people who I'm not working. I don't really like it when other people are working. All these people say, hey, I need the money, but I'm curious as to what your position is.
Well, certainly, bar advocates are essential for the justice system to work here in Massachusetts. They are needed. Many defendants rely on bar advocates for representation. We do have a lot of very well qualified bar advocates that work, and in order to keep those well qualified bar advocates working, their rates should be compensated to somewhere similar to what the rates are in neighboring states. And so unfortunately, Massachusetts is the lowest compensation rate for bar advocates.
Think again, not familiar that much, but like state, neighboring state of Rhode Island. I think they almost pay twice as much as what we pay.
I believe over 110 probably.
And it may not have applied to you, but have you taken any bar advocate cases since this work stoppage?
The work stoppage began on May 27th. I have had a couple of duty days since then, but when the nomination came down in June, so it really didn't, it was only a couple of weeks that I had worked until the nomination came down.
Once the bar advocate, the work stoppage began,
Mhm.
whether it was 1, 2, or 3, you did take some cases.
Yes,
I'm just curious, and so you did not support, at least at that point, for that short period of time, the bar advocates who decided not to work.
at that point, no, and I think mostly Worcester County did not take a real position with regards to the work stoppage. It really started in Middlesex and Suffolk counties, and currently it's moving towards, it's moving west. So we are seeing a little bit more people participating in the work stoppage at this time.
Any other questions? Just I was under the impression, and I'm not that well educated in this, that it wasn't like, and I totally could be crazy here, it wasn't like the Suffolk, Bar Association, or the Middlesex opposition is blank. Maybe there was a position like that, but I just thought it was, hey, okay, I'm supporting my fellow bar advocates, I'm not working for, hey, you know what? I'm gonna go to work because I need the money. I didn't think it was as coordinated as making your suggestion, right? You know better than I do. Yeah, you have a nice resume. Yeah, and again, Councilor DiPaolo, big supporter, and when your name comes before the council, you can count on me.
Thank you.
Thank you.
Thank you, Counselor. Counselor Ziegler,
Thank you so much.
it's awesome to see you.
Great to see you as well. Great to be here. It's great to meet you in person. And congratulations again on your nomination. We had a lovely conversation where we talked about your experience. Of course, you mentioned your 26 years of experience and speaking with you and looking at your questionnaire and your application. It's clear that you have a good diversity of experiences within your background. In our conversation, we talked about many things. One of the things that we started off with was why now? And you talked about this being a perfect time for you. You are ready to jump in and really make a difference. You mentioned during our conversation that your priorities would be to make sure that all parties are heard, but specifically that all kids are heard. Can you talk about what strategies you would apply in make that conversation?
Absolutely. And making sure that kids are heard is making sure that they are well represented by qualified attorneys, because their voice is really through their attorneys. It comes through in the courtroom itself. Making sure that if they have any issues, that they are able to really discuss it with their attorneys, to bring it to the forefront. As a practicing lawyer, I know that when I practiced and there are issues with juveniles, whether it's mental health or substance abuse or any of those types of issues that they may be facing, I try to bring it up to the forefront. Of course, with their permission, but also try to bring it up to the forefront to make sure that those issues are really being addressed for these juveniles. And I think that that's the way that I would be conducting my courtroom is confirmed.
That's very important. You know, we also talked a little bit about accountability. Asked you how you would seek to make sure that everyone is prepared, right, within your courtroom. And you talked about your experience as a supervising attorney, which is something that I think is refreshing. I don't believe that we've had a candidate before us that's had that experience. So you would bring that to the bench. I liked how you mentioned that you would, you know, if there was an issue in which counsel was not prepared to represent their client, would take them aside and have a conversation to get them back on track outside of the courtroom, and then, you know, reconvene. I think that's extremely important because having these types of sensitive conversations during a hearing could cause trauma. We talked about trauma and how you know, you mentioned that virtually every client that comes before the courtroom has some sort of trauma that they're experiencing. It may be traumatic for them even going to the court themselves. Can you speak to how you would create an environment that was reflective of, or that help to support clients who were experiencing trauma, in addition to, you know, strategies that you mentioned when we spoke about taking counsel aside if they were perpetuating that trauma?
Absolutely. I think the biggest way that I would do that is making sure that the courtroom is run in a respectful and dignified manner. And yes, I think it's very important to try to gain insight of these individuals based on what's going on with them. You know, if you have a child that's coming into the courtroom with a lot of delinquent behaviors, but you're seeing it happening maybe only at school, and the child doesn't do anything at home, then you're looking to see, you know, what is going on at school that is really causing the behavior to happen. Is there bullying going on? Is there something else that's happening at school that is causing the behaviors? So trying to get more insight into situations that way.
And my last question is, you seem to have a good understanding of the issues that are surrounding the court right now. You talked about the caseload. You spoke with Counselor Anella about other issues that are facing, right? Staffing issues with counsel, being underpaid, things of that nature. How would you, so two-part question, how would you seek to alleviate some of the issues that you see impacting the court relative to caseload? And part two, what resources do you currently see that the court offers that could be expanded or could be restructured to better serve individuals that are coming before the court?
Absolutely. So some of the what we're seeing is trying to run the court in a much more efficient manner. I think that would alleviate some of the issues with the court, making sure that cases are heard timely. It's very important so that no one is sitting there lingering, waiting for matters to be heard, and it helps the docket move a little bit quicker if you're able to have cases heard in a timely manner. So that would alleviate some of that. Certainly, having more judges available to hear cases is important. Having more attorneys available for cases is very important, especially on the care and protection side. You have cases, on care and protection cases, you need at least 3 to 4 attorneys to represent parties aside from the DCF attorney. So for parents, for children, you know, some children require more than one attorney to represent them because they have different goals. So you need to have additional attorneys for that. So certainly making sure that the court has a sufficient amount of attorneys to represent clients is very, very important. With respect to the second part of that question. I think we have some courts have certain resources that they provide within the court system itself, whether it's programs for juveniles to participate in order to educate them about behaviors. So would be to expand on some of those types of resources, and also accessing some resources that might be in the community to help families as well.
Thank you. I appreciate your thoughtfulness in answering my questions. Of course, you know, this is a very important role. You're dealing with individuals, juvenile youth who are most vulnerable, right? So that's why the conversation around strategies to make the court more efficient and how you would structure the environment within your courtroom, should you be confirmed to be one that is conducive to a less trauma-inducing environment. So congratulations again on your nomination. Appreciate our conversation. Thank you.
Thank you, Counselor. Counselor Jacobs, thank you for your patience. Counselor Jacobs should have gone first in the typical order of our council, so I appreciate her graciousness.
At all. It's good to see you again. Thank you for coming out and spending time with me. I really enjoyed meeting you at that point in the conversation that we had. I want to start with, after our conversation, the one area that left me a little concerned was work-life balance. It's clear that from an early age, you have been the kind of, the number of hours between working and college, and then law school, at the same time that you were working multiple jobs with, I still can't quite figure out how you got any sleep at all during that time. I'm gonna ask, we talked about it then, and I kind of ended up with a little like, I do want to hear from you how, from the standpoint of self-care and you know, avoiding burnout and your own wellness, and how that will be reflected in the culture of the courtroom that you will helm. Your thoughts around managing you know, the work of the juvenile court, but the personal work of maintaining your own well-being.
Absolutely. So as I told you, I started working very, very early in life. I was a teenager when I started working, and I've been working around that 40 years now. I think it accounts to, you know, whether it's, you know, working 2 jobs, going to school, working while having my kids, trying to manage my time that way. And I think, you know, in life, you look at your life, and you look at what needs to be done, and you push through it. And you know, I've done that throughout my life. Thank God. I feel like I have the supports around me to really help me do that, and be able to manage my work, to manage my home life. And I don't think I could do that without the supports in my life, whether it's my husband now, my children, my mother when I was in law school. So I give them a lot of credit for really supporting me and being around me and providing me the strength really to push through this.
So I'm left with the same concerns I had before with the pushing through versus the maybe like giving yourself grace to take time, but I'm gonna leave it there and just leave you with the thought that you know, sometimes pushing through isn't the answer to, you know, when you're hitting a place where burning out is possible. Like, you know, there's other approaches that I would recommend explore. And the second part being just for you personally, but also for those that look to you as a role model, bench for court officers and clerical, and they will, you know, I think the busy, productive culture isn't always the healthiest for human mental health. I will say I appreciated other parts of our conversation. You know, when we talked about your family, it's clear how strong, how supportive, your family went through a lot of transitions and what could easily be categorized as, you know, traumatic experiences, and clearly has a very, you know, has come together and supported you and vice versa, in your family. And I bring all that up because I appreciated so much of your thoughts around family systems, in the juvenile court. And I say that because, often when I interact with people who have beautiful families, like healthy families, emotionally supportive families, they don't quite grasp that other families aren't like that. They may understand there's problems, but they can't conceive of a time when families should be split apart. Parental rights should be removed, where, you know, if they had a wonderful grandparent, all grandparents are amazing and need to be in someone's lives, and you don't seem to suffer from that. And I kind of attribute it to empathy, the true empathy, where ability to understand that which you have not experienced, and the impacts of it. So having said that, I do want to give you the opportunity to share what your thoughts are around how you would evaluate, like what criteria would you use when those sorts of decisions are before you, in terms of, you know, maintaining or separating family structures, siblings, whether they should be together or not, guardianships, whether, you know, the grandparent is, or another family member, or a completely non-familial, and how would you approach that, and what criteria would you use in thinking through those decisions?
Sure. The ultimate goal really in care and protection matters is to making sure that you are providing for the children, making sure that what is happening, what is going to be done is in the best interest of the children. So that could take different forms. It might take the form of what is in the best interest of the child is really to be reunified with the parent, knowing that the parent has addressed the issues that brought the case to the court. In other instances, the best interest of the child is really to be adopted by a different family, because maybe the parent has not done what they really need to do. It has not really addressed the issues that brought them to the court, or that there might be some issues with the child, with the children themselves, whether they need special education, special services, that the parent can't really meet those types of services for the child, that it is in the best interest of the child to be adopted and not to be reunified with the parent. Some other instances with regards to siblings, I am a great supporter of siblings being in the same placement as much as possible. We do face a lot of instances where children are placed in different foster homes during dependency of the case, or even placed for adoption by different families. It's unfortunate, but I am a supporter of them being together. And if they are not together, I would love for them to at least have a relationship, be able to have some sibling contact and have relationships with their other siblings, to know their family, to continue to have a bond with their siblings. That is certainly with the caveat that sibling contact is not interfering with, or is not putting another child at risk. Let's say, if one of the children has significant behavioral issues that has prompted that one particular child to not be in the same home, as long as that contact with the other siblings is not detrimental to those other children. I am a believer that they should have sibling contact.
No, I appreciate that added nuance, because I think that's the crux of it, right? So in terms of on the delinquency side and sentencing, I noticed in your I think it was in the questionnaire, might be the application, talking about the discernment of the judge, or the ability to have discretion in sentencing. So first off, just to clarify for my own self, juvenile court only sentences DYS, right? If the DOC level, it's at superior court if there's like a murder level.
So,
right?
so DYS, and also if it's a case that's a youthful offender case, the juvenile court does have jurisdiction to sentence beyond DYS to House of Corrections or state prison after that.
Including state prison. And what are the times when it would rise to the level of a House of Correction or DOC level?
Let's say a child is placed, committed to DYS to age 21 on a youthful offender case. To age 21 on one criminal count, but a second criminal count, they are placed on probation for that. And their probationary period extends beyond their 21st birthday. And so there's no longer jurisdiction to DYS anymore beyond their 21st birthday. And if they violate the conditions of their probation, and the judge at that point has discretion to impose the House of Correction sentence.
And that would still be a juvenile court judge?
That would be juvenile court judge on a youthful
Even though they're after.
offender case.
Okay. So, but I am under the impression there are 14-year-olds who have been sentenced to DOC custody for crimes like first-degree murder type crimes. That's a different juvenile.
That is, they're treated as a youthful offender. On a murder is different than some of the other offenses. Yes.
Okay, so juvenile court is dealing with murder cases, you're saying? Have you visited DYS lockdown facilities? And have you visited?
All the time.
To visit your clients?
Yes.
Yeah. How about on the DOC side? Have you visited some of our state prisons?
I have not had a juvenile in DOC. I have visited adult clients in the House of Correction and also in state prison, Department of Corrections. Yes.
So kind of a complicated, multi-pronged question, but I'm curious about your thoughts around sentencing criteria, how you would evaluate, particularly for the more serious crimes where we're talking about a lockdown, be it DYS or House of Correction or DOC facility. You're thinking around where and why you would employ your discretion in terms of sentencing length. And if there are creative nuances, I know sometimes judges do get creative in terms of alternate streams of programming they want to see or what have you. Which leads to the second part of the question, which is your thoughts around diversionary, when it's appropriate to employ diversionary, what you're looking for. And I guess a third component of this question is how much you factor in what the impact of determinations at juvenile court will have on that youth into their adulthood in terms of carrying a criminal record and the impact of that. That was a lot, and I apologize.
Tackle them one at a time. With regards to sentencing, I think judges should really have discretion in sentencing juveniles or even adults. It allows the judge to really not only look at the individual, look at their circumstances, look at the facts of the case, and weigh it against obviously the public interest on that. So it does give the judge some discretion, a lot of discretion in really looking at the individual defendant, looking at their circumstances, and I think that that's important. With regards to diversionary measures, we do employ a lot of diversions in the juvenile court at this time. A lot of the low level, what we would call low level offenses, especially for juveniles who do not have a history with the court, to give them the opportunity to have diversion prior to their arraignment, so that nothing is on their criminal record at that point. So it gives them the opportunity to either do a program or a probationary period to be out of trouble, so that nothing goes on their record and the matter would be dismissed at that point. And I think I'm going to need you to repeat that third question.
Well, I think you just answered the third question in terms of the record, protecting when possible.
When possible.
allowing for the kind of diversion that if availed can lead to successful redirection and not have that potential impact as an adult in terms of, you know, not being able to pass a query check, not being able to get federal student loans, you know, things like that that can really hamper really being successful. So I think the component that I'm still looking for is when assuming you're sitting in a delinquency court and you're hearing the kind of case that is serious enough to rise to the level where sentencing could include DOC or House of Correction versus DYS. Searching for the word, but as the potential placement, what criteria would you use in term, what ability to have discretion do you have as a judge, and what would you employ in terms of making that decision on the outcome of where that juvenile would end up serving time?
So certainly on a youthful offender case, juveniles would be going to DYS. It would be for a longer period of time. It would be till their 21st birthday, currently what the law is. So they would be in DYS custody till their 21st birthday. The way that DYS works is it works on a grid level, so that based on the offense, the committing offense, is a grid level as to how long they are actually in custody in DYS, serving their programs. And eventually, once they reach the highest amount of the grid level, then they would be transitioned back into the community with services from DYS, and continue to remain in DYS custody, but not necessarily in lockup in DYS. That allows them the ability to get a job, get a house, you know, live their lives, and you know, hopefully that would be the path for them to really have a better disposition at that point.
I appreciate that. Thank you very much for all of that. I'm good.
Thank you, Counselor. I'm going to be brief because I'm very supportive of your nomination. I just want to touch on a couple points that were brought up during the hearing. The first is, when I was first elected to this office, we'd had a juvenile seat sitting empty. And it continued to sit empty after I was elected. And I see that you applied in 2018 and 2020. You were there, Judge Curry was there, Attorney Jamie Bennett was there. We had really qualified people in Worcester to sit on the juvenile bench. And I just want to publicly thank the administration, this governor, for prioritizing our most vulnerable population and not leaving juvenile seats sitting vacant. I'm so happy to see you in front of us. The last point I want to make, for anyone in Worcester who happens to be listening, I'm aware of the status of the bar advocate situation and how it's trickling into Central Mass. I've been behind where I'd like to be in being a public advocate. I did this morning speak with 2 members of the House Judiciary Committee about this issue. They're telling me they haven't received a ton of outreach necessarily. And so we're at the point where we're looking at supplemental budget for a chance to get this done, to get bar advocates paid at least close to what folks in neighboring states make. In Maine and New Hampshire, you make double being a bar advocate that you do in Massachusetts. I can live a lot more affordably in Lewiston, Maine than in Worcester. And that's before we get to Metro Boston. So you have folks on the council who support you. You have folks in the legislature who support you. You don't need to be afraid to advocate. We need your voices now to make this rise to the level of importance that it is. With that, congratulations on your nomination. I'm going to be very happy to support you. We are going to adjourn this hearing.
Guys, why don't I go ahead and call our meeting to order, and I'd like to recognize Counselor Civil for prayer and leading us in the Pledge of Allegiance.
Let us bow our heads and remember those who have lost their lives in the Texas flood. And keep their family and loved ones in prayer, as well as those who lost their lives over the last weekend in Milton as well in a car crash. So let us remember the value of life, the importance of having it, and to be able to support those at the time of this difficulty they're going through in their lives. I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Right, good afternoon, everyone. It is great to have you here, Counselor Ziegler. I mean, all of our counselors, but particularly you, Jake, and baby Samuel, who is precious and sleeping quietly. So welcome back. We are here this afternoon to comply with the Massachusetts Constitution and the general laws relative to the finalized tabulation and certification of votes cast in the June 10th special state election to fill a vacancy in the House of Representatives. So our first order of business is to understand that these votes were amended after a recount in accordance with state law. So I want to make sure that's noted on our agenda. I don't think we need to take any official action in that regard. We just need to make sure we notice that as part of our meeting. I'd like to recognize Counselor Kennedy for a motion to record the certification that Lisa M. Field has been elected representative in the general court from the 3rd Bristol District in accordance with the preamble I just offered.
Can we look at all the ballots for?
If you'd like to, Counselor, I certainly can make that available.
Make that motion.
Motion has been made by Counselor Kennedy, seconded by Counselor Ziegler. All in favor, say aye. Any opposed? The ayes have it. Thank you very much for that and for not wanting to see every single ballot. I'd like to recognize Counselor DiPaolo for a motion to record advice and consent for the financial warrant.
So moved.
Is there a second?
Second.
Seconded by Counselor Civil. All those in favor? Any opposed? The ayes have it. I'd like to recognize Counselor Kennedy for a motion to record advice and consent for the pending list of notaries public and justices of the peace.
So moved, Governor.
Is there a second?
Second.
Seconded by Counselor DiPaolo. All those in favor? Any opposed? The ayes have it. We also have 2 new nominations. Lisa Kaur to the position of Associate Justice of the District Court. I understand that Counselor Kennedy has scheduled a hearing for July 16th at 11:15 a.m.
That's correct, Governor.
Okay, perfect. So we'll note that. And then the Honorable Joanna Rodriguez to the position of Associate Justice of the District Court. I think Counselor Ziegler, we've got a hearing scheduled for the 23rd at 10 a.m. Is that right? Okay, perfect. Those are duly noted. I think that concludes our business. Seeing none other, I'd entertain a motion to adjourn.
So moved.
Motion made by Counselor DiPaolo. Is there a second? Seconded by Counselor Dolan. All those in favor? Any opposed? The ayes have it. We stand adjourned.